Alrighty. Welcome, everyone. It is 10 o'clock Pacific on the dot. We're going to give it a couple minutes while people join in. We had a nice group of people who have signed up for today's webinar on looking at what is the outlook, right, for 2023 in TCPA world, TCPA land, TCPA universe. There is the Czar of TCPA world, Mr. Eric J. Troutman. How are you doing, sir? How are you feeling?
Man, I'm feeling good. We just got back from Lead Generation World. It was a huge show. I felt really good. We just launched troutmanfirm.com. We have so much fun stuff going on. And now we're going to look into the crystal ball and talk about what is going to be a huge year in 2023.
Awesome. Yes, I'm looking forward to hearing what you think, what you feel. I do feel like there's a lot of disruption. There's a lot that's happening. Yeah, just fascinated to hear what you think. And as always, if anybody has questions, the chat is disabled normally, but the Q&A box is open so we can easily not only answer live, if we can kind of segment each person and keep track of it, but also after we're done, it's easier to follow up also for those who had a question. So make sure if you want to, if we can't get to you, I know a lot of times you're anonymous, which is okay, it's all good. But if you actually register, if you log in, if your name is in there and we don't get a chance to answer you live, it's very easy to find who registered and follow up later if your name is actually, if you put your name in the box when you do the Q&A. So just wanted to share that. It is always recorded, Scott, and we always send out the replay afterward. As well, if you go to dnc.com/webinars, you can find all of our webinars for the past couple of years right there, ungated for all your TCPA enjoyment. So definitely. Very cool. Awesome. Let's see, any other questions? No, we're good. The crowd is standing out. So just gives you context again. So my name is Arvell Craig with Contact Center Compliance. I am the Director of Compliance Services in our consulting division. And what I do, I help our clients understand. I'm not an attorney. I don't act like an attorney, but I'm like a virtual fractal compliance officer. And I help our customers understand all the different regulations and also in how to use our software and our products and integrations to make sure that you can stay safe. And so that's kind of my role. And so if you want to ask any questions about our products and services, I'm going to briefly talk about them when we're done. And but for now, I just want to get started, introduce Eric Troutman. You all know who he is, the Czar of TCPA world. Eric, why don't you just go ahead and get started? Let's just find out, what are you thinking? What are some of the high points as you look at 2023 in TCPA?
Wow. Well, look, guys, there's a lot going on. 2023, I'll just say it plainly, it will be the biggest, most challenging, most disruptive year that anyone's had in the telecom space ever. I feel like there's a lot of forces kind of converging now, trends that have gained steam over time that are really now about to hit a crescendo. And really, if you think about it in the overall cadence of the political calendar here in the United States, it's not surprising, right? We had a shift a couple of years back to a Biden administration, both at the FTC and the FCC. These commissions take some time to get to full strength. We had to get through the midterm to see kind of how that was going to shake out. There was not the red wave that I think many were expecting. And so truthfully, these agencies now who have been hiring all throughout 2022 are now feeling very powerful, very robust. They don't have a mandate in the true sense of the word, but they're feeling like they can operate comfortably for the first time. And we are going to see, I believe, a real breakout, both from the FTC and the FCC in 2023. In addition to, and that's just on the regulatory side, we'll get to some specifics here in a second. In addition, right, we know that there's been, the drips and drabs of new state legislation coming out post the Facebook ruling. We saw, of course, Florida leading that charge. And then we started seeing Florida get mapped into Oklahoma. And then we saw Michigan come up with a really, really comprehensive bill. Again, my intel, we've got some people working on this now, trying to maybe push back a little bit. But my intel remains that is likely to pass in the first quarter. And I am on record believing, and I do believe, that once Michigan falls, Ohio and Indiana will be right behind them. And I think from that point on, you're going to start seeing rubber stamp copies of that bill all across the country. Okay, so we're going to have big proliferation in 2023 at state level. And then alongside that, right, three-headed dragon here, we've got the carriers, right? And we've known for some time that the carriers have been given the default call blocking power, default labeling power. We know that text messages remain information services. So there's a lot of text blocking that's empowered around the texting. We saw in 2021, 2022, the carriers begin to really flex their muscles. But what we're going to see in 23 is, I think, about 5 times what we've seen in the past in terms of blocking. And this is it's being animated by the FCC being exceptionally aggressive. And we can start pivoting now to some specifics with what they're doing with overseeing carriers. And the biggest story of 2022, which will now bleed into 2023, in my opinion, is Earth Access, that Earth Access ruling, which was just massive. And to level set for anybody, I did not cover this on TCPA World because frankly, it was too damn scary. And I did not want the plaintiffs bar to get a hold of this and start running with it. But I did cover it on the 9th edition of the Deserve to Win podcast. That's when we're all in pajamas. So you guys should go to YouTube and take a look at that right after you get done watching this. So in the Earth Access ruling, I mean, you guys got to stay with me. This one is bizarre. Okay. The FCC actually shut down a telecom carrier. All right. This is not against the lead generator, a lead seller, a caller, a call center. It's at the carrier level, the actual carrier that was carrying traffic for telemarketers. The carrier was issued the death sentence by the FCC. Shut the business down, guys. The carrier was shut down because they were carrying telemarketing calls that were being made without consent. Now stay with me because it gets even weirder, okay? The calls at issue were for like student loan reduction programs, right? Like take advantage of Joe Biden's $10,000 deal. Now it's unclear, right, in the ruling whether or not those were scam calls, which means they might have been legitimate calls. There might actually be companies out there helping customers, presumably for a fee, to navigate how to take advantage of the federal program, okay? Now it could also have been a scam. I don't know, but the point is the FCC didn't seem to care, right? Earth Access was not shut down because they were carrying scam traffic. It might have been perfectly legitimate traffic. They were shut down because they were carrying traffic calls made without consent. And here's why. Even though the calls were about a student loan reduction program, when the ITG, that's the Industry Traceback Group, hopefully you guys all understand this ecosystem, right? If you're a carrier, you of course are regulated by the FCC. There's a watchdog organization, a private consortium called the Industry Traceback Group. This is run by US Telecom. Industry Traceback Group issues things that are lovingly called tickets in the industry. And a ticket is when traffic is detected by the ITG, usually by reports from private enterprises like Umail and other scam and spam reporting apps. Will tell the ITG, hey, we think that there's fraudulent traffic. ITG will then go to the carrier and say, hey, what's up? Why are you carrying this traffic? So ITG went to Earth Access and said, what's going on with these calls? Earth Access said, whoa, guys, these are legitimate calls and we've got consent. And they provided to the ITG consent that was provided by the telemarketer. Here's where it gets even weirder, right? So far we understand what's happening. These different players. So ITG, right, looks at the consent and it's from a Go Health website. The Go Health website provides consent for, the Go Health website is for Medicare. It's for medical insurance, right? Now down in the fine print, there's this language that basically says you can be contacted by any of our marketing partners basically for any reason, right? It's one of these broad, stupid disclosures that I always tell you don't use because it's going to get you in trouble. Well, here's what happened, right? So this student loan reduction program bought leads, it looks like, okay, I'm putting some of these pieces together, but this is what, according to the ruling, this is what happened factually. They bought leads from the Go Health website, which was again, driven toward insurance and Medicare products, but did contain the express written consent disclosure. And the marketing partner list listed the seller of the student loan program there, right? So the student loan program says, hey, look, I got a disclosure. I'm a marketing partner on the list. It says I can call. Sure, it was a Medicare website, but who cares, right? It's the consent. They opted in. I can call. FCC says, no. We're not playing this game. first of all, because it was a student loan reduction program, the fact that they went to a Medicare website or a health insurance website, that is dispositive of consent. You cannot get consent for this program on a website that is not regarding this program. Multi-vertical consents were just nuked by the FCC. It's a really big deal. And they did it without any notice to the industry, right? There was no NPRM, no notice of proposed rulemaking. They didn't ask for comment. They didn't say, dear industry, what do you think about this? They just said, it's dead, okay? Now this was in an enforcement proceeding, right? So this is what's called in the industry, right? Regulating through enforcement. We don't know what the rules are until we come down on you and issue the death penalty. Can you imagine that? Like in like the regular old country, you're just like walking around doing something that no one's told you illegal. Yeah, maybe you think it's illegal, but like no one's ever told you it's illegal. And then you get captured and then some judge says, I've just decided it is illegal and now you get the death penalty, right? Like that'd be crazy. And that's just what happened to this carrier. So that's issue one. There's a second issue here, which I think is even more important for most of you listening, which is the marketing partner list. The marketing partner list had 5,200 names on it. Again, this is alleged, in the ruling. I have not gone back to the website and clicked the button to confirm, but this is what the FCC ruling says. All right, 5,200 marketing partners, and the FCC said no. If you have a list with 5,200 marketing partners, that is not consent for anybody on that list. So think about that. Let's say that you are a Medicare provider. Right? Somebody goes onto this website, which is a Medicare website. Your name is on the marketing partner list. The subscriber or the consumer is interested in your product, fills out disclosure, hits the button. You buy that lead. It looks perfectly clean. You make your outbound call. Guess what? The FCC just said you did not have consent for that call. Can you imagine how many people bought leads off that website and are now going to get sued? And the commission's ruling might be given Hobbs Act jurisdictional deference. Now, it might not, following a PDR Resources Supreme Court decision that probably isn't final legislative action, it probably shouldn't get deference, but the point is, the FCC just said your 5,200 person marketing list doesn't give consent to anybody. So if you're buying leads, you better be paying very close attention to how many people are on the marketing partner page when you're buying them. If you're selling leads and you want to stay in business, you got to start thinking, holy smokes, how many people am I allowed to have? And that's the big issue also. The commission didn't say where the line is. It just said 5,200 is too many, right? Obviously, I wouldn't recommend 5,199, but what if you've got 2,000? What if you've got 200, right? Where is that line? I'm starting to tell people, and look, this is less legal advice as much as it is the czar prognosticating and trying to think, what can I defend in court? I'm starting to think between 60 and 100, somewhere in there is going to be your limit. So you've really got to be thoughtful. And of course, we're trying to create reach, get that off the ground. I want to kill, the entire concept of repeat selling of leads, repeat aggregators, or selling to partners, selling to partners, selling to partners. I want to get to a place, and I think this is what the FCC wants to do. And I know the carriers do too. We're going to switch to that in a second, the telco carriers. We want to get to a place where the lead is sold essentially just to the ultimate service provider, the good or service provider. So if you are an operator of a website, you're going to have a direct relationship with the seller of a good or a service. You will not sell through aggregators. Essentially, aggregators will be dead. Everybody's just be a generator running their own website. That's where I want to get to. Now, we're not going to ever, is that going to happen? I don't know. But in the short term, I understand that's a huge departure from where we are right now. But you've got to be really thinking through what your disclosures and what your marketing partner lists are going to look like. Because, look, the commission just killed somebody. And again, I'm not even talking about and understand, this isn't the marketer that got shut out of business. This is the carrier. The carrier presumably didn't even know about this until the ITG ticket came down and they got killed. So now imagine you're a telecom carrier and you're being asked to carry telemarketing traffic. And you're looking over at Earth Access saying, wait a second, those guys just got nuked because their telemarketing traffic, it turns out, didn't have the right level of consent. Half the carriers in this country have got to be looking in the mirror thinking, do I even want to carry marketing traffic anymore after that, right? So if you think the environment was challenging in 2022 navigating the carriers, wait till 2023. And that was like the first development I wanted to talk to you all about, because I think that has massive implications, again, on carriers, on deliverability, on getting your traffic through. I think there's a watershed moment right now. And then of course, secondarily, for those of you in the lead buying and selling game, that's a huge deal, right? Can you buy leads with how many names have to be on those marketing partners list? And multi-vertical disclosures are essentially dead. Co-reg is essentially dead. That's what we talked about lead generation world, Pooja and I. So, I mean, again, this is all opinion, but we're going to find, you just saw it in a ruling. So, I don't expect the FCC to back away from that and say, yeah, we changed our mind. No, you're going to see more of that, not less of that.
Let me recap how the issue was discovered. You said most likely it was possibly one of those apps that recognize it. Those are the ones that are going to be monitoring the traffic, like UMail or whoever, and they contact the traceback group, who is the official FCC people, and they would talk to the FCC. It's kind of like that's the chain of events.
Yeah, that's the chain of events. Isn't this wild? So you have to understand how it's working right now in the robocall mitigation universe, right? Is basically there's like 1,000 companies that are like narcs, right? And they, just to pick on UMail. I love UMail. Alex Felici is the CEO over there. He's a good guy, but that's why I pick on him, because he's big. He runs the robocall index. So it's like UMail, right? Some users got UMail. This is literally how it works. Some users got UMail, gets a call. It's like, well, that sounds like scam. Pushes some button, off it goes. What it does is it actually sends to the UMail little, fraud monitoring group a copy of the pre-recorded voicemail or a copy of the actual communication, which is recorded in the little phone app. Okay, they'll look at it, they'll make whatever assessment they want. Again, these are totally just private actors beyond any form of regulation. It's just wild what's going on right now. They'll make their determination, yeah, this smells like fraud, or that's fine. If they say it smells like fraud, they'll pass it off to the ITG, right? ITG works in partnership with these guys, so they really trust what UMail and others are doing. But ITG has its own level of review. They'll take a look at it, they'll make a determination. Does this smell bad? Does it not smell bad? If it smells bad to them, they'll go right to issuing a ticket to this carrier. Carrier, under penalty of death by the FCC, has 24 hours to respond, to tell the ITG, did I, the carrier, originate that traffic, or did I get it from somebody else? And they have to go down and down and down and downstream until they find the originating carrier. Once it gets to the originating carrier, here Earth Access, now Earth Access has to come up with some evidence to defend itself, right, in this. I'm not going to call it a kangaroo court. I love the ITG. I love the US telecom guys. But you can imagine, these are just like, private individuals working for a trade organization, right? Who have been like blessed to be like a knight in shining armor by the government to go find the bad guys. So they make their determination. Once they, decide good actor, bad actor, using whatever criteria it is that they use, right? I mean, it's up to them, complete discretion. They can do a number of things. They can report to the FCC. They can report to the FTC. They can report to the DOJ, which they often do. They can report to the AGs. They can report it to the states, right? There's a communication line between the ITG, which is a remarkably powerful organization right now, and all of these different stakeholders who have enforcement abilities. So just understand, right? It is, panopticon is not quite the right word, but there are a million eyes on everybody right now. And the people making a determination in terms of whether or not your traffic ends up in front of a regulator, it's highly fractal. It could be 100,000 different people in this country, right, that receive your message, could get you just one little report, could get you all the way in front of the FCC right now through this chain I've just explained. It's wild. It's a wild kind of environment.
Interesting. Well, yeah, I do want to pause for 1 second and just to clarify, and there's some questions in here I see in the Q&A. And again, I was wondering about that chain of events, because again, I don't know what all the details were, but I do wonder, even though the FCC is not contacting the customer or directly, or the traceback group isn't contacting, but I wonder when the issue first started, I do wonder were there signs when the marketer was when the buyer was making those calls initially. I wonder if there were small flags. I wonder if there was small things that they ignored, that they didn't think that were that serious, that these apps may do, your deliverability, call monitors, all these things. So I wonder if there were signs that they could have seen earlier. And I do want to highlight, and that's what we do. I just want to make sure, for those who don't know, that Contact Center Compliance actually has tools that actually will show you how your calls are being monitored, if there's FTC complaints, and we monitor the app companies as well. And we kind of remediate, we consult, we advocate for our clients and let them know we're kind of like a middleman in the situation. We've got clients that are monitoring their traffic and those flags and things. So we do try to bring clarity and visibility to actually what's happening. And I wonder if they had someone advocating on their behalf before the issue went crazy, if that would help them. So I do want to make sure if you don't know, remediation@dnc.com, if you don't know what your traffic looks like as a caller, as a buyer, I just want to make sure that people know that we may be able to help you initially, but once it gets down the line, who knows what happens.
Yeah, no, I think Arvell, what you're driving at is important. And frankly, it wasn't a point I was going to make, but I'm glad you brought it up because it is a point I should make, which is I think in 2022 and before, your services, caller ID monitoring and remediation was like a nice to have. But I think after Earth Access, it might be a necessity, right? I mean, the day will come not long from now when the carriers are each carrier, of course, is going to make its own decision. But when they are largely saying we're carrying first party traffic only, and we're only going to carry first party traffic through validated channels, right? I mean, that day is not far from here, following Earth Access. So, if you've got a service where you can be a validated channel, you can do white labeling, of course, through Reach. We're trying to set standards that are all largely first party and that we can kind of get that direct carrier relationship going. We've got, Brian Jones-Lanzi, the head of compliance over at Cinch, a major aggregator, who's serving as our pipeline to the carriers to help the industry on the Reach trade organization side. But, having something individually like what DNC offers. I mean, look, I don't promote services, but I mean, it's a huge deal. This Earth Access thing is huge, and the carriers are still kind of getting their arms around it. And there's going to be blowback. There's just 100%. There's going to be blowback. So you should be thinking about it.
Yep. So
that's
got a couple questions.
That's just one thing.
Okay, so I'm just gonna let me see. Okay, these are probably quick answers. Do these issues apply to both B2B and B2C code calling?
Yes, absolutely. Yep. Right. The issue is not, B2B, B2C, vertical specific. The issue is, is the traffic wanted by the call recipient? The end, right? And if the carriers decide that your calls aren't wanted, if the FCC decides that the calls were illegal, and my God, if anyone decides that they were fraudulent, forget about it. Now, everyone listening to this, you guys aren't fraudsters, right? You're trying to comply with the law. You're good actors. You're good people, and I know that, right? So what you want to make sure you're doing is not falling down because you're making calls without consent, right? That you're making calls, riding that gray, and you can imagine the carrier, right, and ultimately the caller in this Earth Access scenario. They got their Jernaya. Their Jernaya says, right, here's a disclosure. I consent to call. I'm on the marketing list, right? They probably think they're doing, if they don't have good counsel, they probably think what they're doing is legal. And that's the problem, right? And all of you listening to me, you guys are you're the A+ students, right? You're not the B- students. You're not going to fall into this trap, but you want to, of course, kind of be in a position that you're demonstrating and communicating with the carriers and with others that you are a good actor. And of course, that's where Reach comes in. That's where this DNC stuff comes in. But it doesn't matter. B2B, B2C, don't ask me questions like that because it makes me nervous, okay? It is all the same to the FCC.
Yeah, I like that. And I will make one comment. You can go forward. One thing I was mentioning at the conference a couple of days ago was like, people used to think compliance was like the gold standard. And my message is compliance is the floor. It's not the top. You said, are the calls wanted? Hey, we're compliant, we're legal. Like, that's the floor. You have to get from just being compliant to wanted, desired. And, it's safer, right? It's safer to go beyond just having, like I said, a tag or getting that consent. There's more details to it. So I like how you said, kind of evolving our definition of what's a good actor, what's a good caller. Next
other questions?
Again, somebody said kind of the same thing. If a telemarketing calls are manually, does that protect me against regulatory measures you summarized?
So a manual call, right, to a number on the DNC, hopefully you all know this, right, is still illegal, still a violation of the DNC rules of the TCPA. A manual call, though, when you're scrubbing the DNC and you're making that marketing call, okay, those are still legal in this country. Now, the carriers might attempt to block it, but it should not end up, and I say this knocking on wood because God knows what's coming next, right? But it should not end up in front of the commission. This should never become like a really serious problem because manual calls, again, to numbers not on the DMC are perfectly legal. You're still allowed to make those calls in this country. Now, the carriers, unfortunately, have been given such incredible discretion to use, reasonable analytics, whatever that means, their black box algorithm formulas that they don't have to share with anybody to decide what calls are wanted and unwanted. So despite the fact that those calls are perfectly legal, the carriers might still block them. But if a ticket arises, first of all, it shouldn't. But if a ticket arises from the ITG on that issue, highly, highly, highly unlikely, in my opinion, to result in any kind of action by the commission. And if you find yourself in a situation where someone's coming down on you for manual calls when you scrub the DMC, give me a call. We'll take a look at that, because that shouldn't happen.
Yeah, thank you. Awesome. Let's see. One other question. We do legitimate calls, and it's getting more and more difficult to do business. However, I get more and more spam calls on my Vonage and T-Mobile lines. It seems that the laws are designed to make it more difficult for real legitimate businesses to operate, and doesn't seem to affect illegal operations. Okay,
yeah,
just renting.
Yeah, and that's a massive problem. And I, every time I'm liaising with the regulators and with the commission, I'm always trying to beat that drum. It's like, guys, you got to think about what you're doing here, because you're making it more challenging. That's the problem with the TCPA to begin with, right? The TCPA has never brought down a scammer, right? The TCPA has never been used against an offshore spam account. The TCPA has never been used to stop the real problem. The TCPA is used against the good actors in this country. And when you look at the evolution of the TCPA being expanded by the commission, specifically to give the commission more power, right? If you look at the whole arc, the whole thing is the TCPA was small and weak. The FCC got a whole bunch of complaints back in 2000, and in 2003 started the bit by bit expansion of the statute, specifically because it wanted more power that Congress never gave it in order to go after the bad guys. Up until this year, I think the FCC has done a very good job of only going after the bad guys. I'll give the FCC credit. Its enforcement arm has been focused on true spammers, true scammers, bad actors. And I respect that. The problem is that everything the FCC does to give itself more power is actually given effect to these individual people who can bring their own lawsuits, right? And so they use the extra power that the FCC essentially gave itself. They take that power through the use of the private right of action, and then they wield the same sword that the FCC does. And whereas the FCC goes after the bad guys, these guys just go after anybody with money in a bank, right? So the truth is, it has become a lot harder to comply. And then at the same time, the TCPA does absolutely nothing to stop the scam calls and the bad calls. Now, I'm trying to stop the scam calls and the bad calls. And when I do, I want to take my success, and I think we're going to be successful. I'm going to go to the commission. I'm going to go to the carriers through reach. And I'm going to say, guys, look what we did. You failed. Love you. You failed. Okay. We as industry got together. We created standards. We stopped 500 million to 1 billion robocalls a month, which is my goal, by requiring fraud detection on leads, by limiting the number of times that leads can be sold, right? By getting to I'm going to ASW in 2 weeks. I'm just going to go there and wag my finger at these guys. And I'm going to say, you better not be committing fraud, because I'm going to find you if you are, right? And then I'm going to take that success to the commission and to the carriers. And I'm going to say, you guys failed. This TCPA's entire regulatory framework, your stupid call blocking, all of it was garbage. The bad guys kept getting through because you never got to the root of the problem. We're going to get to the root of the problem, right? And then hopefully we're going to be able to affect policy. We're going to be able to affect regulatory change. We're going to keep hopefully good callers in business, because hell, let's be honest, right? It's a story no one tells, but telemarketers give great value to consumers. It is an absolutely critical, especially post-COVID, by the way, absolutely critical line of communication between product offerers and consumers who need them, particularly some vulnerable individuals who need these products and services and might not be able to get out into the store through a channel that they can do it other than through the phone, right? So this is really, really valuable. It's a backbone of American commerce. It's under constant attack. No one is defending it. And really the problem is that people believe that every marketer is a scammer. Every marketer is a bad robocaller. We got to turn that whole perception around. But I'm glad that you said that. I didn't mean to launch on a tirade, but it is true, right? The good actors continue to have the sword of Damocles hanging over their head for no reason. The bad actors don't care, right? And by and large, so long as somebody's willing to buy bad traffic, the bad actors will continue to survive. So we need to shut it down at the lead buyer level. And the buyers need to take responsibility. That's what Reach is all about. It's a buyer side organization saying we will not buy leads unless they're fresh leads straight from a publisher, or they've only been sold once or twice, or and there's very clear, transparent disclosures, black letter, white, black lettering against a white background, like really, really clear stuff. The goal being that every consumer who ever receives a call is expecting that call from that caller, right? That's what the FCC wants. It's what the carriers want. It's what I want. They're doing it stupidly. I'm going to do it intelligently. We're going to get it done.
Gotcha. Got it. Next topic. We'll go ahead and pause this one and go on to we got 30 minutes to go. So
yeah. Okay. So yeah, let's kind of speed up some things here. So let's talk about state laws. Everybody knows about Florida. I hope you all know about Florida. Everybody knows about Oklahoma. The Michigan bill, of course, Arvel, you and I did this fantastic breakdown last year. It's just a bill that has not yet passed. Again, there is some efforts to try to affect policy there. But the state regulators, right, the AGs of the various states have become very, very powerful, very interested in something they haven't been interested in before, which is, enforcing the robocall bills that are already, passed. And what folks are finding, the real impetus behind the new state laws is that, when the AGs in the various states go and say, okay, we're going to start enforcing these robocall statutes, they go and they dust off the books and they look at them and they go, oh, there's not really much here. Right? Every state, as you probably know, every state has a anti-robocall, anti-telemarketing bill of some kind, but the vast majority of them only apply to cold call solicitations, right? And most of them only apply to cold call solicitations made using a pre-recorded voice, right? That if you look at cold call solicitations using a pre-recorded voice, those are banned in basically every state. Now, most of them don't have a private right of action. But that leaves a huge gap, right? Because most of the calls that are quote unquote unwanted in this country, that are being made by legitimate actors who the state AGs who do not have the power of the feds, the state AGs can't go after the offshore guys, right? State AGs have to only go against the domestics. Essentially the only people that they can go after, are legitimate-ish companies, right? That's why you're seeing a lot more activity there. But they need, in their opinion, they need bills that give them more teeth and more power. And that's where the FTSA came from. That's where the OTSA came from. That's where this Michigan bill came from. So, we could say it in a sentence, just we're going to see more proliferation of these state laws. Pay attention to TCPA World, DNC.com. Of course, we'll have a lot of reporting around when these new bills crop up. They're part and parcel of some of the new privacy bills that you're starting to see coming up in other states as well. So just please keep an eye on that. If you need help with registration in various states or kind of with understanding the state law, again, DNC.com has got fantastic resources. We've got fantastic resources at Troutman Firm. It's so weird. We're 33 minutes in. It's the first time I've mentioned the name of my law firm. I'm a lawyer, for those of you that don't know this. Troutmanfirm.com. You can check it out. Brand new, cool, shiny website. But we do have resources to help you. But the states is where kind of the biggest news is coming. That doesn't mean that the federal TCPA, which we're going to actually talk about here at some point, the federal TCPA continues to be very important and very deadly as well. But the developments are happening now at the state level. So you really got to pay attention to that, especially in 2023. Good. Should we talk about, let's talk about the TCPA a little bit, just kind of state of the universe right now at a high level. I think 2022 brought us, a pretty good number of the auto dialer cases. I think where we are currently is the defendants have largely won that battle. I think there was a lot of question following footnote 7 of the Facebook ruling along the lines of what does and does not constitute an auto dialer, especially when you're talking about latent capacity. We've seen now a couple of Circuit Court of Appeals rulings, 2 of them published, 1 of them unpublished, all of them taking a very narrow view of what an ATDS is post Facebook. Now, interestingly, they've all taken a different view. And the most recent ruling in November from the 9th Circuit Court of Appeals in a case called Borden, it goes the furthest. Now, it's a great case for those of you who like short-term gains. It's a horrible case for those of you that are looking at long-term risk. In Borden, the 9th Circuit Court of Appeals said essentially that unless you are using a system that is randomly generating telephone numbers, you are not using an ATDS. Now, that is, to me, it's a reasonable read of the statute. We might all say, well, that makes sense. That's good. That's perfect. The problem is, of course, that's not what the Supreme Court just said in Facebook, right? In Facebook, the Supreme Court said that using a random or sequential number generator to either create telephone numbers or store telephone numbers to be dialed is the use of an ATDS. So the Ninth Circuit, and I've got a visualization on tcpaworld.com of this, the Ninth Circuit ignored half of the framework that the US Supreme Court just handed down. It says you have to be generating telephone numbers. The Supreme Court says, no, you have to be generating or storing telephone numbers using that ROSNG. So the Ninth Circuit just completely ignored the Supreme Court, which I'll tell you, you can't do. So now we're going to be in a situation where the district courts in the footprint of the Ninth Circuit are going to follow the Ninth Circuit, right? And so callers in California who are calling other people in California or Washington are going to feel very confident, and frankly, they should, right? That their calls are not made using an ATDS, say if you're using a predictive dialer, because you're not generating telephone numbers, right? The problem is that if the Ninth Circuit ends up, if the Borden ruling ends up going to the Supreme Court, which it might, because for instance, the Third Circuit in Panzarella, a different circuit came to a completely different decision in terms of how to apply the Facebook determination. So there's a split of authority. If that ends up again in front of the Supreme Court, the Ninth Circuit's position is going to get tossed out, right? So everybody relying on the Ninth Circuit's very, very narrow ruling is at risk that, 4 years from now, they can get sued again, because as you all know, there's a 4-year statute of limitations. And what the Supreme Court does is retroactive, which is horrifying, right? So today you're complying with the law, but 3 years from now, if the Supreme Court says, no, Borden was wrong, guess what? All of these calls you're making in reliance on Borden, they're instantly become illegal, right? After the fact. They were legal at the time they were made, and now they're illegal. It's a terrible thing, but that's what we've seen again in the arc of the TCPA history. Those of you that have been living in this world for 12 years like I have, you've seen it over and over again. A good development, retroactive liability. A good development, retroactive liability, which is why the TCPA world is just known as this trap, gotcha kind of place where you have to pay very, very close attention to everything. And that's why I'm saying Borden is a great decision. And most lawyers, I think, appropriately will tell you, hey, look, it's a big development. That's good for you if you're a caller. But I'm telling you, it's good for you if you're a caller in the short term, but please be careful. I would recommend you not change your reliance on express written consent for marketing and express consent for non-marketing calls, because again, the Supreme Court might change direction on you, and you don't want that to happen. So that's one kind of big set of developments. I think another big set of developments in the TCPA will pivot away from marketing. We'll talk now about informational calling a little bit. The recent ACA ruling, really nice work by the ACA. I'd like to see good advocacy to the FCC that effectuates change. But let's kind of go back in time here. We know way back at the beginning of time, 1991, when the TCPA world began, the commission was given the authority to exempt calls that it found did not intrude upon residential subscriber privacy from the reach of the TCPA. And in 1992, right, way back in 1992, it said if you're using a pre-recorded voice message for business purposes, not marketing, you can leave as many of those messages as you want on a landline, and you don't have to have consent. The thought was that, consumers are expecting to hear from their doctors and their dentists and their lawyers and whoever. And, if they want to use a pre-recorded call to leave that message, that's fine. So the Trace Act passed back in 1991, or sorry, back in 1991, that's funny. The Trace Act passed back in 2019, in which Congress said many things, but one of the things it said in Section 8 was, hey, FCC, go back and reconsider that blanket exemption that you gave to every American business to leave voicemails for people, because we think that's too broad. And so the commission in a ruling from December 2020 did in fact reconsider the limitless number of pre-recorded calls that could be left for non-marketing purposes on landlines. And it said, you know what, we're going to limit that to three per month. Now, the way that the CFR was going to be edited to implement that change would have meant that after 3 per month, you had to have express written consent which essentially meant anybody that was leaving an informational message, they're not going to have express written consent because you don't need express written consent for informational calling, right? So why would you have express written consent when you don't need it? So that essentially meant that everybody was now limited to just 3 calls per month, regardless of whether or not you had regular consent, because nobody had that express written consent that the CFR edit would have required. So an organization called ACA International, good organization, the same group that went off and challenged the omnibus successfully back in 2015 in the ACA International ruling, right, bears their name from the DC Circuit Court of Appeal. That same organization went and challenged the FCC's ruling regarding the implementation, again, of this 2020 limitation of pre-recorded voice calls for informational purposes, just 3 per month. And they were very successful. Now, they didn't get everything they wanted. They wanted to set aside the 3 per month as arbitrary and capricious and as violating the US Constitution. There's a footnote there. It's really interesting when we talk about that. But what they did win, and which is a really important win, is that the FCC admitted, you know what? We blew it. We made a mistake. Mea culpa. We didn't do it on purpose. You're right, ACA. After those 3 calls per month, a caller that has regular express consent can still continue to leave pre-recorded voicemails, again, for informational purposes. The one other important thing that came out of ACA International is this entire framework of implementation of this limit had been on hold because, again, the FCC wasn't really at full strength. There was a lot of let's see what happens with the midterms, et cetera, and it had been on hold, had not been published in the Federal Registrar. And so really, even though this had been on the books, quote unquote, since 2020, it never became effective. You couldn't enforce it against anybody. But following the ACA International ruling, now that the FCC has had a chance to reconsider its implementation, it has now stated that it will very swiftly be publishing the final rule in the Federal Registrar, which means that this will be effective now within 6 months. So by the end of this year, this 3-call limit for non-consented pre-recorded informational calls to landlines will be on the books and enforceable. So keep that in mind.
Awesome.
Fun.
Yeah.
All right. Anything else you want to talk about, Arbel? I can keep going on some other topics, but I just want to pause, take a breath, see if you want to chime in here.
Yeah, I want to ask about, you didn't yet talk about, the whole FTC's involvement with looking at the lead generation. It was kind of mentioned from the FCC perspective, but the FTC, right, has been involved now, feeling like the TCPA is not strong enough. You're right. So anything you want to address on the FTC's role in dealing with calling and consent farms, or whatever you want to call it?
So it won't surprise you to hear, right, that I'm an FCC practitioner by and large, right? I'm mostly focused on the carrier side, the telecom side. And the split, right, in the universe is essentially FCC is looking at communications, broadly communications. FTC is looking at advertising, generally advertising. And it really comes down to, is there consent, is the call wanted, versus was there trickery, right? Is the content of either the message or more usually the content of the creative, right? The content of the website that the consumer is looking at, right? Is that tricky? And the FTC, you are correct, has come down extremely hard on something called dark patterns. Now, this is living largely outside of lead generation, although there are tie-ins, and there's also places where the FTC was more direct on lead generation. But on dark patterns, for instance, there's been a couple of companies that, for instance, made it hard to unenroll from services. And the FTC just hammered a company for like $100 million, where it was making it too hard for some. It's really easy to sign up on a website, but then when you want to, unsign up, you have to go through like 6 different iterations, and it becomes very tricky. And they'll put like, distractions in front of you so that you can't complete the little tiny font down at the bottom, like this big thing up here to get you to click on this, and you're supposed to be trying to unsubscribe. And the FTC is paying very close attention to what's called dark patterns, right? Which is where a consumer is interacting with the website, trying to get to what the consumer wants, but the operator of that website is constantly trying to get the consumer to get tricked, essentially, into doing something else. And the FTC hates that. The tie-in there to lead generation, of course, is that it is very, very common, right, for a lead generator, a publisher, to be offering a Walmart gift card, right? Offering, some sweepstakes to get that consumer to kind of go through a funnel And maybe a picture is loading in a way that the button pops up just as they're trying to click the not interested, and instead it goes to the interested, right? You see these kinds of like little tricks all the time. The FTC is onto this, guys. And I'll tell you, last year, I was reporting on TCPA World. The FTC was continuously hiring for new lawyers and new staff in its privacy group and in its consumer-facing groups that are designed to look at specifically online marketing. They are staffed up. They've got a ton of resources. Again, this is a priority for this organization, right? In the Biden era, now that we're talking about the FCC being at full strength, which just happened back last April, like they're coming out guns blazing. Yes, they're looking at, not just at lead generators, right? So this is not just lead generators, but they are really focused on lead generators as well. And so any trickery, any content that's misleading, even if it's mostly okay, but it's like, okay, well, there might be some edge cases where that's not true. Trust me, guys, like they're going to hammer you. And that's an issue. And then CMS, for those of you in the Medicare space, you may know, the new TPMO rules, they are really, really coming down hard on the words that can be used in the lead generation process and putting it on the carriers. Now, I'm not talking telco carriers, now I'm talking insurance carriers, to make sure that everybody in line that's providing a lead anywhere in the chain, that they are responsible to make sure that their content requirements are met. I'm hearing that that's really causing rumblings with the insurance carriers, where they're like, well, we're going to bring this all in-house then. We're going to stop buying leads completely, right? And kind of circling back to a broader point, right, of pressure on the lead generation industry, haven't even talked about the public knowledge request to the FCC that essentially all consent forms be deemed to be invalid once sold. All right, so backing up, the FTC, CMS, and the FCC are all coming down very hard on the lead generation world right now. They have finally started to understand the role that lead generators play in the robocall epidemic, right? In my view, most telemarketers, right, the direct-to-consumer marketers, the callers, generally are innocent parties. They only want to talk to people that they want to, that are interested in their products. Very few of them are doing cold call solicitations. They're paying good money for leads for people that want their products and services. And by and large, in my experience, they're being tricked, duped, and lied to by lead sellers. Not all lead sellers are bad, of course. Some of them are my very good friends and I love them, but many are scumbags, all right? The FCC, the FTC, CMS, they've all figured this out. They've all figured this out, right? And the question is, how hard are they going to come down on this industry now? The FCC in particular is looking now at a ruling. Can you imagine this? That says express written consent is not valid if it is sold. It can only be provided directly to the caller, period. Right? That is being considered right now by the commission. Nobody, to my knowledge, has submitted any comments to oppose it. And that is why I'm, one of the number one reasons why I'm creating this REACH organization, which I keep mentioning, who will need to put together standards quickly. We already have a draft set out there. Get in front of the commission and say, dear commission, we know that you want to do this crazy thing where you can't sell consents. Don't do that. Here is a really good rule that says you can sell consents, but only really valid consents. And it's good for the consumers and it's good for, of course, American industry. And here's what the consents look like. And please bless this instead. Right. And that's my plan, because I really don't want the entire industry to get shut down. But that's what we're staring at right now. So understand, FCC, FTC, CMS, for those of you in the lead generation world, all of these folks are looking like magnifying glass on you guys right now. We're going to have the head of policy in the Consumer Government Relations Bureau of the FCC, pretty important person, on stage with me at LeadsCon in March, along with Ronnie from DNC.com. It's going to be a hell of a panel, and Beth Sprague, who's the head of the reassigned number database, all together talking through primarily the use of the reassigned number database, but also, right, like, guys, it's going to be a moment up there, because the FCC is coming down to Georgia, right? And they're I mean, it's not really Georgia, you know what I'm saying? The devil's coming down to Georgia. The FCC is coming down to Vegas, and we better have a plan, because this industry is not going to last long at the rate it's going right now. So,
Yeah, let me throw out
Right.
one thing that's interesting. We had our TCPA compliance summit in Florida just
Mhm.
a month and a half ago, and we had the FTC there speaking on stage. And one thing was interesting that I caught that's really helpful. He implied he can't tell you what they're doing. He's like, I can't tell you specifically who we're going after, but he very clearly said, go to our website. We're posting, we're updating, we're almost telling you what we're looking at and where our concerns are. And so I just noticed in my email yesterday that the FTC put out this consumer alert. You go to consumer.ftc.gov, and the headline was, don't answer another online quiz until you read this.
Yeah.
So if you use online quizzes as part of your lead generation strategy to sell that data in a way that's not clear and conspicuous, but in other words, that is one specific thing that they are looking at. And so so mainly they're giving their tails. And there's one other thing from last year, it was like December, want to buy now, pay later, read this first. So I'm just going to highlight two.
Yep.
Of course, that's an industry. That's if you're in debt or whatever, or financial services and that relate to that. So I want you to pay attention to the FTC's consumer alerts page and their updates, because that is specifically where they're looking at. They're giving you, a tale as far as where they're concerned about. So that's just something I think is important for you to just watch.
And on that line, I mean, look, there's a major lead supplier, I will not name because I love, but major lead suppliers, public record that the FTC is going after right now for sweepstakes giveaways, right? If you are using multi-verticals, if you are using sweepstakes, if you're using the quizzes, if you're using any trickeration, I know it sucks, right? Like, this is a new paradigm, guys. Everything that we've been doing for the last 10 years, I'm telling you, it's going out the window, right? If you're using any trickeration to get these consumers to come to your site and you're doing something to trick them, even if it's like pretty clear, into giving some form of consent that doesn't have anything to do with the reason that they're on your website, you are in harm's way. And and these reach standards, which have been circulated to a select few, sweepstakes are dead. They will not meet the reach standard, right? Every single consumer that provides a valid consent under the reach standard is going to be looking for information and services. That's what's driving them to that website. So you can't use these ancillary ways to get traffic only to try to, hey, I've got 1 million people a day coming to my website. Some of them are going to want auto insurance. So, let's see what happens. No, it's just that way of generating leads. It's just not going to last, guys. So we have to get into the new paradigm. We have to start mentally thinking to ourselves what that future is going to look like. And the future is going to be consumer friendly.
Yeah. So we got 7
minutes.
Let's get to some questions. I'll address one from Kim Davis. He says, do you put on a conference specifically covering all these types of topics? So Kim, if you don't know about the compliance summits, the T-Space summits that DNC has been putting on for almost 20 years, that is definitely the one deep dive conference specifically on the topics where we're talking about. Eric is always there. He's always our featured speaker, guest, so definitely check out when we have our compliance summits, we do have them. They go deep, 1 or 2 days, and this is all we talk about. So I just wanted to cover that question. Let's see. I'm going to start from the bottom. Let's see. Wasn't the do not answer that online quiz, was that about data security, not necessarily about lead gen or consent? I don't know if that's specifically talking about that article from FTC. It might be. But again, like Eric mentioned, there has been a specific lead generation case from the FTC that relates to quizzes. So if that article is talking about data security, that doesn't negate that the entire genre, the strategy, the pattern of using quizzes to capture customers is something being looked at it in all its various flavors and forms.
Oh, absolutely. And guys, it goes hand in hand. Understand, it goes hand in hand. That's why I always talk about privacy stuff, right? The Troutman firm does 2 things, TCPA and privacy. And it has to do privacy. I would rather just do TCPA forever. But they go hand in hand, and the regulators look at them hand in hand. They look at lead sellers as data brokers, for God's sake, right? So trust me, yeah, the FTC might be using language about data protection, but it's thinking consent right along the same lines. Make no mistake.
Is there anything on data privacy that you want to address as far as
Well,
anything in like any big points? Since
well, the hugest thing in the whole wide world, right? I mean, you guys should be onto this, is the California Invasion of Privacy Act and the eavesdropping statutes, the wiretapping statutes around web session replay technology following the Javier case, right? Just said it real quick. I know we only have 5 minutes. I'll do this in 2. Right? Active Prospect, trusted form, right? Fantastic product. All of you should be using it if you're buying or selling leads, or either that or Verisk's Janaya product. These are web session recording technologies, right? They sit on somebody's website, they record keystrokes, they record the little mouse movement around, and courts are still battling, but the prevailing theme right now is that the use of that technology constitutes wiretapping under the state of California and other state laws, which means it could be up to $5,000 per session, per visitor on your website if you don't capture consent first before you start using Active Prospect to record what takes place on the website. I know what you're thinking, but I use Active Prospect to record consent. Yes. However, you first have to get a different consent, the consent to use the web session recording, to use Trusted Form, before you can then use Trusted Form to capture the consent of the consumer for TCPA purposes. It is now a 2-step dance. I know it's crazy. I want to pull my hair out too. That's why I don't have any hair. That's why I always wear hats. But in truth, it's a very, very significant development. That is the biggest issue right now in the data privacy world. Additionally, and so you guys should really be paying attention to that. Again, we have a feature called CIPA Sunday, CIPA, C-I-P-A, California Invasion of Privacy Act, on tcpaworld.com, where we're breaking down these developments as they happen every week. We're going to be launching CIPA World soon because it's huge, right? These cases in particular, but more broadly, privacy litigation under BIPA and other statutes is really starting to reach crescendo. I talked to Law 360 last month, which is one of the biggest, if not the biggest, rag that does news on the legal industry for lawyers. And I told them, and I'll tell you, because I believe it is true, that 2023 will be the biggest year of privacy litigation in history as well. Just like we've got these huge determinations and issues on TCPA, privacy litigation is also going nuts. We've got resources for you. We're happy to help you. Not to mention that there's five states considering new privacy legislation in 2023. It's just fun. 2023 is going to be a breakout year for lawyers. By the way, I'm hiring. If you guys know any attorneys that are looking for a job and they're really super badass, have them give me a call, because I need about 8 new lawyers this year. That's how big it's going to be. And it's going nuts. Anyway, there you go, Arvell.
Yeah, no, again, there's a lot of questions, and I knew there's gonna be a lot of questions. And again, we can only do so much on these webinars. And so we definitely just want to give you a taste of what's happening, what's coming up. If you don't know, some people ask for Eric's website. It's troutmanfirm.com. Of course, tcpaworld.com is how you reach him and how you contact him, how you follow the latest news, the alerts. It happens multiple times a day. There's always something happening. So definitely subscribe there. If you guys want to contact dnc.com, again, this is my email address. Specifically, if you have a consulting question, if you want a free consult on what I do, definitely that's that email. And I also wanted to mention, we talked a lot in the first 30 minutes about the caller ID, about carriers, about things being blocked. Again, I want to encourage you, you have to pay attention as soon as it starts. Some of you are saying, does it work with manual calls? I mean, honestly, it's about issues, about consumer problems. There's going to be problems. So if you're not weekly and watching the data of your calls, if you're not getting reports, we do this for our clients. We give you real-time alerts as what's happening, what's being reported, and we advocate for you so that you can know what's happening. So honestly, if you can pay attention on the ground level before it goes to the traceback group, before it gets out of hand, then you can probably protect yourself. So email remediation at DNC. You can scan here to book appointment to talk to our remediation team. But honestly, pay attention to it. And I mentioned the call branding, which is just honestly, you first have to make sure you're remediated. First, you got to make sure that you're compliant. Then maybe we can talk about branding, because nobody's going to brand your call if you're getting these flags, these alerts. Verizon or AT&T are not going to allow any branded call to show up if you're not understanding, you're not paying attention to the spams and the issues and the complaints. So I just want to make sure all of you know about that. And again, Eric, any last words? Again, we've got more events coming up. You'll be at ASW. We'll both be at LeadsCon in March. Any final parting words that you want to dispel?
No, I love you guys. I mean, I'm sorry to be the bringer of bad news. I know it's going to be bumpy. You're going to get through it. We can get through it together. We're always here to help you. At the end of the day, the regulators, by and large, don't go after good actors. And if you put yourself in a position where you've got good policies, procedures, you're using good vendor tools like DMCs, and you've got a good story to tell, like, you can continue to operate in this environment. You can still make money. I know it sucks. Not as much money as it used to be, not as easy as it used to be to do it. But there's still plenty of meat on that bone. Don't give up. We're here for you.
Awesome. Thank you, Eric. We appreciate you for sharing your time, your wisdom. I just want to thank you on behalf of us and everybody watching. We just thank you for what you're doing. And again, we appreciate you all for joining us today. We will send a replay. There's a lot of meat in this webinar. So definitely, if you got to watch the replay, if you have to transcribe it, if you have to, put it on Chat GPT to get some AI to interpret it, do what you got to do to pay attention to what's happening and take notes, contact us for our software, our solutions. And besides that, create a great day. Thank you.
Thanks, everybody.
See ya.